court delivered its judgment in Williams No. 2 on the 19th of June, and as you know, it once again found that the payments in question were not validly made. The court decided, on the narrow basis argued before it, holding that it was unnecessary to resolve the issue on the broad basis contended for, that insofar as provisions enacted in 2012 purportedly provided legislative support for the program, they were to that extent invalid. It was for that reason that the court chose not to deal with the question of whether the Act itself or the amendments introduced in 2012 themselves were invalid. Their reasoning was confined to the legislation insofar as it purported to validate the chaplaincy program. Now, as I said at the start, the court was not concerned with the merits of the chaplaincy program. It was concerned with the question of whether legislation purportedly authorising the expenditure for that program was itself supported by a constitutional head of power. The effect of the decision was to reaffirm the reasoning of Williams No. 1. So the authority of that case, and at the time the decision was delivered, there was some academic debate, given the variety of reasons that the judges gave as to its full scope and meaning. The effect of Williams No. 2 is to put beyond doubt the authority of Williams No. 1. In the context of our larger theme today, federalism, the Williams decisions and the Pape decision before them are important and interesting for the limits they apply to Commonwealth power, particularly the Commonwealth's power to spend, and therefore to the Commonwealth's relations with the states and the Commonwealth's power within the federal system. As the Chief Justice observed in his reasons for judgment in Williams No. 1, there are consequences for the Federation which flow from attributing to the Commonwealth a wide executive power to expend monies, whether or not referable to a head of Commonwealth legislative power and subject only to the requirement of parliamentary appropriation. What is particularly important about both Pape and the two Williams cases is that they constitute a break on the general trend since Federation of responsibility and power shifting from the states towards the Commonwealth. That trend, which most scholars trace to the engineers case, has only accelerated in all the years since, until now, until the Pape decision and the two Williams decisions. The accretion of power and responsibility at the Commonwealth level over the last 113 years has, of course, not merely been as a result of judicial interpretation of the Constitution. It's also been the product of decisions by the people in the 6 successful constitutional referenda we've had, and reference of powers from the states under intergovernmental agreements on occasions. The visible consequence in the current day-to-day division of roles and responsibilities between the Commonwealth, state and territory governments is that a division which is far removed from the balance that existed at Federation has been created, until recently very much a balance in favour of Commonwealth power. Against that historical drift, the Williams and Pape litigation mark an important turning point. They also mark, in a policy sense, the backdrop to a decision of the Abbott government, which on the 28th of June released the terms of reference for a white paper on reform of the Federation. Those terms of reference were developed in consultation with the states and territories and are informed, among other things, by an appreciation of the consequences of Pape and Williams. The white paper seeks to clarify roles and responsibilities between the different levels of government with a view to 3 particular objectives: reducing, if not ending as far as possible, the waste, duplication and second-guessing between the different levels of government. Secondly, to achieve a more efficient and effective federation, and in doing so, improve national productivity. And thirdly, to make interacting with governments at federal, state and local level simpler for citizens. We need to reduce and, if possible, end duplication and make interacting with citizens' transactions with government simpler. We do need to clarify the role and responsibilities of the different levels of government as far as possible. The Commonwealth will continue to take a leadership role on issues of genuine national and strategic importance, but there should be less Commonwealth intervention in areas where the states have a primary responsibility. That view of the Federation, which shapes the government's thinking, was evident in a number of the decisions that were made in the course of the budget process. The reforms that the Abbott government will seek to enact or to bring about in consultation with the states also seek to ensure that our federal system is better understood and valued by Australians, has a clearer allocation of roles and responsibilities, and enhances the autonomy and political accountability of governments at their respective levels, as well as supporting Australia's economic growth and its international competitiveness. Within the constitutional framework, consideration will be given in the development of responses to the White Paper to the practicalities of limiting Commonwealth policies and funding to core national interest matters, in particular the subject matter topics listed in Section 51, reducing or, if appropriate, eliminating overlap between local, state and Commonwealth responsibility or involvement in the delivery and funding of public programs, achieving agreement between state and Commonwealth governments about their distinct and mutually exclusive responsibilities and subsequent funding sources for associated programs, and achieving equity and sustainability in the funding of any programs that are deemed to be the responsibility of more than one level of government. The reforms are designed in part to address the increasing involvement of the Commonwealth in matters which have traditionally been the responsibility of the states and territories, and the increasing reliance of states and territories on Commonwealth revenue to deliver services which states and territories themselves provide. It's fair to observe in conclusion that the principles arising from the Pape and Williams decisions, although they run counter to a century's drift of power and responsibility from the states to the Commonwealth, are nevertheless entirely congruent with the government's objectives to re-empower the states and the territories and to confine the Commonwealth's power, in particular the power to spend, within orthodox constitutional boundaries. Whatever else might be said about Pape and Williams, the cases serve to remind us that there is undoubtedly more than one way to understand Australian federalism. The way in which the court, under various Chief Justiceships, understood federalism from engineers onward has now been cast in a new light. And in the light of the emergent doctrine and the very real challenges it represents to Commonwealth spending programs across a vast range of activities, many hundreds of programs, the Abbott government is concerned to advance a coherent and inclusive debate about the proper roles of the Commonwealth, the states and the territories in the Australian Federation. In doing so, we will be following on the heels and learning from the wisdom of the court's decisions, to which we owe to the late Professor Pape and Mr Brian Williams. Thank you.
Ladies and gentlemen, this is a great opportunity to ask questions. There will be two roving microphones around the room. When you do step up to ask a question, if you could please state your name and where you are from before asking that question. I just have to say that 40 years ago when I went to Melbourne University, advanced constitutional law happened to be one of my most favourite subjects. I had Gareth Evans teach me constitutional law and Professor Colin Howard teach me advanced constitutional law, and that vexed question of federal-state financial relationships 40 years ago was alive and well, and it's still a critical factor today. I guess as a host I get the privilege of asking the first question, Senator, so here goes. Given a national partnership agreement on legal aid expired in June and has been extended to June 2015, and given the parlous state of legal funding in Victoria and unmet legal need, can you give us an insight into your intentions for legal aid funding and, in particular, lifting the Commonwealth share?
Thank you. Well, we're not proposing to lift the Commonwealth's share, but we do acknowledge that the Commonwealth has an important role as a provider of legal aid funding, in particular through the state and territory legal aid commissions, through the community legal centres, and through the ATSLs, the Aboriginal and Torres Strait Islander legal services in particular. I know it's an almost tedious thing to say, but it needs to be said because it can't be said often enough. When the Abbott government was elected, it did inherit a very bad financial situation. Public finances, the level of public debt in this country had never been higher, and never been anything like as high as they were, with public debt expected to peak at $667 billion unless economies were made and savings were found. So, with the exception of Defence and the National Security Services, whose capabilities had been significantly eroded in the previous 6 years and which were quarantined, savings had to be found in every portfolio, and that includes the Attorney General's portfolio. But I am very, very mindful of the importance of the Commonwealth making a contribution to legal aid funding for simple social justice reasons, apart from the importance of efficiencies in the judicial system, which are compromised by unrepresented litigants. So I've sought to focus the legal aid spend on casework. There's been a debate for a long time now, particularly in the community legal sector, about the use of, about the allocation of expenditure between casework and what is called policy or advocacy work. I have a very simple view of this. When there is not enough money to go around, I would prefer to see all of the Commonwealth's money, indeed all of the money, spent on people, on individual clients. These are always people in necessitous circumstances. They are always people who find themselves before a court, whether a criminal court or a family court in particular, and are in need of legal representation. And I think it is just wrong, when there isn't as much money in the system as we would wish there to be, for individual clients to go unrepresented because some of the money provided to legal aid providers is spent on policy or advocacy. If the lawyers want to engage in advocacy, that's fine. It's a free country, they can do what they like. But the Commonwealth's contribution should, in my view, be spent on casework. And so by focusing the Commonwealth's contribution on casework, I've sought to mitigate and ameliorate the effect of some of the reductions. Now, those considerations and others will inform the Commonwealth's final position on the new National Partnership Agreement, which, as you say, will commence on the 1st of July next year and is currently the subject of development.